Hi, this is Elisa Taub. I'm an immigration attorney with Siskind Susser, and the subject of this webinar is going to be H-1B hot topics. We're going to start off covering some topics that are really, as of the moment, things that are happening this week and last week. And then we're going to go through and kind of talk about how the H-1B process works. What is an H-1B visa? What does it mean to be in H-1B status? And then we'll kind of wrap up with that. Okay, so let's get started. I'm going to start off with a quick update on a few H-1B hot topics that are really burning hot, and then we're going to jump back and talk more about the H-1B process. The biggest issue that's currently on with H-1Bs is premium processing. Premium processing is a government service through which USCIS, the Immigration Service, will adjudicate or handle a petition that is filed with them within 15 calendar days. That includes weekends and holidays. And they charge a filing fee of $1,410 for that service. And since probably March or April of 2018, that service has been in limited suspension. It started off with just suspending premium processing for H-1B cap lottery cases in 2018, and then was expanded this past fall to include a larger group of cases that were not eligible for premium processing. And then over the last few months, USCIS has been bringing it back incrementally. On Monday of this week, on Monday, March 11th, USCIS announced that as of Tuesday, March 12th, premium processing is now available for all H-1B petitions. This includes petitions that are already pending. Those can be upgraded, as well as new petitions that are to be filed, may be filed with premium processing, regardless of the type of case they are, or who the employer is, or where the person's going to be working. The one caveat to this is that after making this big announcement and getting everybody all excited, USCIS came back and said, well, hold on a second. This announcement does not apply to cap lottery cases to be filed in the first week of April 2019. USCIS is going to make another announcement with regard to premium processing of cap cases soon. And we don't know exactly when that announcement is going to come, but we believe it will probably come in the next week to 2 weeks, obviously before the cap lottery filing season for this year. So stay tuned for additional premium processing information about H-1B cap cases. But for now, all other H-1Bs can be premium processed, which is great news. The other big hot topic that I know a lot of folks who are on H-1Bs are interested in is the H-4 EAD. For those folks who have spouses in H-4 status who are using EADs for their work authorization, or for those who might be in H-4 status themselves on EADs, this is a really big topic because the government has signaled very strongly that it intends to eliminate this program and to do so as soon as they possibly can. The update there is that in February, the Department of Homeland Security sent its version of a proposed regulation to end the H-4 EAD to the Government's Office of Management and Budget, OMB. OMB will review the regulation and determine whether it's proper, whether it's all properly vetted. And if they believe it has been, then they will send it back to the Department of Homeland Security and let them know it's okay to be published in the Federal Register as a proposed regulation. And once that happens, there'll be an opportunity for the public to comment on the proposed regulation to end the H-4 EAD program. Any member of the public is allowed to comment on the regulation. So you do not need to be a U.S. citizen to comment, and you do not need to be a U.S. permanent resident to comment. So anybody who's here on an H-1B or who has an H-4 EAD or anyone else with an interest in this topic is welcome to file a public comment. You can do it online. And it's a good idea. It's a way to get your voice heard on the topic. The public commenting period will be open for probably around 30 days or so, maybe more, probably not less. And then the government, once the public comment period closes, the government is required to review all of the comments that are submitted before it issues its final regulation. And it needs to respond to the comments in issuing its final regulation. Needless to say, there can be several months in between, OMB getting a regulation, sending it back saying it's okay, the proposed regulation coming out, notice and comment, and then waiting for a final regulation to come out. We also expect that once the final regulation comes out, it's going to be challenged in court. So the bottom line is that the H-4 EAD, while under threat, has not yet been eliminated. The government has not even taken the first formal step of issuing a proposed regulation to eliminate the H-4 EAD, and our office continues to file them. My expectation is that all H-4 EADs that have been issued will continue to remain valid until they expire. I don't believe that USCIS is going to come back and try to revoke those, but we won't be able to extend them or apply for new ones if the program has ended. So for that reason, we're still filing them. USCIS is still approving them and still issuing H-4 EADs within their normal processing time. So it's a good idea if you're on an H-4 EAD or considering seeking an H-4 EAD to consult with legal counsel about this, because there are some very serious considerations, and you want to make sure that you have some sort of plan B or backup plan in place or in mind if you're on an H-4 EAD or seeking one and the program ends. Rest assured it's not going to end abruptly. You're not going to wake up one morning and find out that your work card isn't valid anymore, but it's important to kind of think about these issues and discuss them with a professional to make sure that you're adequately protected. So those are the two really quick updates that I wanted to provide that relate to H-1Bs. And from there, I want to kind of go back and talk, kind of take a step back and talk about, well, what is an H-1B to begin with, and how do we find ourselves here? So H-1B status is temporary work authorization for somebody who comes to the U.S. to work in a specialty occupation. And as you can see from this slide, a specialty occupation has a very specific definition under the law. And basically, it's a complex job that requires at least a bachelor's degree for minimum entry into the field. Well, for that reason, doctors are quintessentially eligible for H-1Bs, because I don't know any physician position that requires less than a bachelor's degree, and I don't know any doctors who don't have at least a bachelor's degree. So for that reason, it's usually not controversial to obtain to convince the Immigration Service that a doctor is qualified for H-1B status. But there are other issues that tie in with the H-1B that can be a little bit difficult to assess in the process. And it's important to understand that it's not just about proving that you have a job and you're qualified for the job when it comes to doctors, but there are a whole host of other issues that tie into the H-1B question and the H-1B process. You'll see on the next slide that we're going to talk about some critical issues in the process. I could probably spend an hour speaking about each one of these bullet points on the next slide. We're not going to have time for that during this webinar, but I want to give you a flavor for some of the analysis that goes into determining how we file H-1Bs. What happens when your immigration lawyer is looking at your contract? What are some of the things that we're looking at? And what are some of the things that aren't really important in the H-1B process? So that's what we're going to cover in the next few slides. So critical H-1B issues. One of the first things that I look at when I'm assessing an H-1B for a physician is, what is their salary going to be? What are they going to be paid? There's a requirement in the H-1B law that says that any employee on an H-1B must be paid the higher of the prevailing wage or the actual wage for that position. The prevailing wage is the wage that is paid on average to somebody working in the position in the geographic area where this occupation is going to take place. And the actual wage is what people in this position for this employer are actually earning. If you're the only person working in that position for that employer, that's the actual wage. If there are multiple people, let's say you're working for a company that has 10 hospitalists working for them, then you're going to be compared to people with similar education, training, and experience with regard to that position and determining what the actual wage is. The purpose of this provision is to make sure that employers aren't allowed to hire folks on H-1Bs at a lower wage rate than what they would hire American workers at. Usually for physicians, this is not such a controversial issue. Most of my physician clients, my employer clients, are paying the required wages. But every now and again, there's a question about what the actual wage is for a position, or we look for alternative sources of the prevailing wage, because sometimes the Department of Labor's information is a little bit skewed locally. And so we look at wage surveys or other options for determining what the prevailing wage is. So that's a big issue. And we'll talk a little bit more about that in a few minutes when we talk about the process of filing an H-1B. Another issue that comes up a great deal with physicians, especially those who are using H-1Bs for their residency and fellowship programs, especially for fellowships, is that the fact that you can only spend 6 years in H-1B status. Now, there are ways to get beyond that 6-year maximum if you get to certain milestones in the green card process, and if you happen to be from a country that is backlogged for the green card process, Indian nationals and Chinese nationals are able to get 3-year extensions of their H-1B forever until their priority dates are current and they can obtain a green card, so long as they reach those milestones within that 6-year period. For other folks who might not be in a green card backlog situation, it's really important to look ahead and see, okay, I have 6 years on my H-1B. I need to make sure that I'm working with an employer or working on my own somehow to seek a green card or to seek some other alternate immigration status within those 6 years, because when I get to the end, it's going to be really hard to get too much further beyond that 6-year period. So it's a very important thing to be looking ahead at, especially if you're using your H-1B for training, especially for subspecialty fellowships, because some of those folks, you'll finish out your fellowship and you'll have used 5 years of your H-1B time, or sometimes even 6 years of H-1B time, and it becomes an emergency right at the end of that period to figure out how you're going to continue working in the United States. So it's really important to consider that at the beginning of your training program, or at least on the front end, so that you can have adequate plans in place to deal with that 6-year maximum. Note that H-1B workers or H-1B doctors do not have to be working in an underserved area. The only folks for whom an underserved area is important are those doctors who are seeking a J-1 waiver based on working in an underserved area for 3 years. If you are not in that category, working in an underserved area is completely irrelevant to your immigration status. Working in an underserved area does not get you to be exempt from the H-1B cap, as you'll see in a few minutes. It really is just an irrelevant consideration. The other good thing about H-1Bs versus J-1 waivers is that there are no special contract terms that have to be included in an H-1B petition or an H-1B contract. When we do a J-1 waiver for a doctor based on working in an underserved area, we have to do a very careful review of the employment agreement to make sure it complies with all the rules. With regular H-1Bs that aren't connected to a J waiver, there are no special contract terms. However, as an immigration lawyer, I like to review the employment agreement to make sure that it's not running afoul of some of the H-1B rules regarding wages. We talked about prevailing and actual wage. We need to make sure that there aren't any provisions in the contract that would put your employer out of compliance with those wage requirements. So it's important for your immigration lawyer to just take a look at your employment agreement to make sure it complies with the rules that way. The other thing that's relevant for you and I think is of interest to most folks on H-1Bs who are employees is that your employer must pay all the fees and costs associated with the petition. That includes the legal fees and the government filing fees. And this is really an employer issue. You're probably not going to get into much trouble or any trouble at all if you pay the fees, but your employer is at risk of liability if they pay or if they make you pay the fees related to your H-1B petition. So we want to make sure that employers are paying those fees. It's actually in their best interest to do so and keep them on the right side of the law with regard to H-1Bs. But by far the biggest critical issue, most important issue that comes up with H-1Bs is the H-1B cap. And since H-1B cap lottery filing season is only a few weeks away and is right around the corner, this is a great time for us to talk about what that means and why there's a lottery and how some of that is changing this year. The H-1B cap is the annual limit on the number of H-1B visas that the federal government can issue in a federal fiscal year. The federal government of the United States fiscal year starts every year on October 1st and runs through September 30th of the following calendar year. So for federal purposes, the 2020 fiscal year is going to start on October 1st, 2019. In that fiscal year, the government can issue 65,000 H-1Bs plus 20,000 under what we call the master's cap for those who have a U.S. master's degree or higher, for a total of 85,000 cap-related H-1Bs. Note that for purposes of that master's cap that I mentioned, completing GME in the United States does not count. A residency or fellowship in the United States does not count toward the master's cap. It must be an actual degree program like a master's or PhD or medical degree, something like that. Every year since, probably about 2013, 2014, the U.S. government has received in excess of this number of H-1B petitions. And so the category has been oversubscribed. In the olden days, they conducted a first-come, first-served filing on April 1st for all of the cap cases that were being filed. And the reason why the filing period starts in April is because when you file an H-1B petition, you can do so 6 months in advance of your requested start date. Well, because there are no cap H-1Bs available during the year because they're all used up at the very beginning of the fiscal year, the earliest we can apply for a cap case is April 1st because our start date would be the start of the new fiscal year, October 1st. I can't file one for next week because there aren't any available. So every year in April, there's a cap filing period. And as I mentioned, in the olden days, we used to actually file first come, first served, and you would send out a bunch of cap cases to USCIS and just hope they got there early enough in the day on April 1st to be selected. Because that was a really unworkable process, the government issued a regulation that creates a lottery for H-1B cap cases to go through. And under this process, in the first 5 business days of April, this year, in 2019, it's April 1st to April 5th, the government will accept all of the H-1B petitions that are filed under the cap. And through those first 5 business days, and assuming that the cap is exceeded during those first 5 business days, USCIS will announce that, and the following week, they will conduct a random computerized lottery. So they take some time and they do some data entry on every petition, and they run a lottery. After the lottery is conducted, USCIS sends out all of the receipts for the cases that have been selected. And for the cases that were not selected, they send back all the petitions with the filing fees attached and everything. It's not considered to be a denial. It's a rejection of the petition in the mailroom because the cap was met and that case was not within the cap. So it's not something you have to report in the future as a denial. It does not affect your permanent immigration record or anything like that. We typically find out about the results of the cap lottery by about the middle of May. There's no website or anything that you check. Basically, we immigration lawyers are running to the mailbox every day looking to see if we got cap lottery receipts. And then we do a little dance when we do. And we notify our clients, very happy that they got selected. For those folks who aren't selected, as I mentioned, the government just sends back the petitions. We usually get those by the end of June. But USCIS will let us know when they've sent out their last receipts. So we usually know if a week later we haven't gotten receipts in certain cases, we feel pretty comfortable that those cases weren't selected. For physicians, if you're selected in the lottery, the likelihood of being approved for your cap lottery case is very high. Because as we mentioned earlier, assuming all the issues are dealt with, doctors are quintessentially qualified for H-1B status. So, the issue really for us is getting selected in the lottery. The other issue to keep in mind is that your start date on a cap case is October 1st. So if your training program ends on June 30th, you've got a gap in your status. There's no cap gap for doctors in this situation. In other words, there's no operation of law that provides you with status between June 30th and October 1st. So it's really important to plan ahead and know what you're going to do for those few months. Are you going to go abroad for a few months? Is there some other status we can change you to in the United States for a few months while you wait out the cap issue, the cap case to be adjudicated? So there's a lot of issues to consider when you file a cap case, aside from just the uncertainty of the lottery itself. This year, for 2019, USCIS issued a regulation that changes a little bit how the cap lottery is going to work. One part of the regulation is this pre-registration process that you might have heard about in the news, where employers were going to be encouraged to go onto a website, pre-register all of their H-1B cap cases. The government would then conduct the lottery based on the pre-registration, notify everyone, and then you'd only file the petitions of the cases that were selected. This sounds like a really great option, but the government was not technologically ready to implement it this year. So that pre-registration process is not in place in 2019. The government has said maybe in 2020 it'll be ready, and we'll see. We'll see how that works. On the other hand, the regulation does have a portion that is being put in place this year in 2019, and that is a reversal of the way the cap lottery is held. So all the filing procedures are going to be the same. First 5 business days of April, USCIS will conduct the lottery thereafter. But in the past, what they've done is they've done a lottery for those 20,000 master's cap cases first. And if there were master's cap folks who were still left over after that lottery, they'd roll them into the general cap. This year, they're doing it the other way around. They're running the general cap lottery first with everybody included, and then if there are master's cap folks left after that, and if that exceeds 20,000 still, they'll run another lottery for the master's cap folks. The end result of this is that we expect that folks who do not have a U.S. master's or higher level degree are going to be disadvantaged in this year's cap lottery. We don't know the percentage by which you'll be disadvantaged because we don't know how many cases are going to be filed yet. But we suspect there's going to be some percentage difference in the chances previously and the chances this year. There may be some litigation filed after the cap lottery is run this year by folks who weren't selected in the cap to try to challenge the way that this new system is going to work, because it appears to be contrary to the way the law is written. And it remains to be seen what's going to happen with this new cap lottery process. But that's a big hot topic for this year. I know a lot of folks have asked me about how this is going to affect them, and the answer is, well, we think it might, but we're not really sure, because your odds of winning the lottery, of course, are always dependent on the number of people who enter it. And so we're going to kind of have to see as we go through this year's cap season how this all plays out. The reason why the H-1B cap is really important for doctors to understand is that most doctors who are on H-1Bs for residency and training are in programs that are exempt from this quota. So when you got your H-1B to come here for your training program, this lottery is not something that you ever had to deal with. But now, as you're going to finish your training program, you're going off into the working world. If you're going to go out and seek a job with a private practice or a for-profit hospital system, the H-1B cap is going to rear its ugly head, because for-profit private employers are automatically subject to the cap. That's the default position. But there are, as your training programs seem to be, right, there are employers and work sites that are exempt from this quota. And so there are certain jobs that you can look for that will get you around having to go through this lottery. One thing I should mention is, for doctors who obtain J-1 waivers based on working in an underserved area, they are not subject to the cap at all. They are personally exempt from the quota. What this means is that if you get one of those J-1 waivers, necessarily you're going to change to H-1B status at the end of that process. The cap lottery does not apply to those doctors. They do not have to worry about this. They will automatically zoom through that process as exempt from the cap by themselves. And that personal cap exemption is going to extend even after they finish their 3 years of service. So the discussion we're going to have on the next slide about H-1B cap exemption is irrelevant for doctors who have J-1 waivers based on working in an underserved area. Just wanted to make sure I provided that clarification. So let's talk about this. How is an employer or a worksite exempt from the cap? You'll see on this slide that there are 3 kinds of institutions that are exempt from the H-1B lottery. And that means that if you obtain a job with an institution like one of these, or if you're going to be working a majority of the time at an institution with these characteristics, that you might be able to obtain an H-1B that's exempt from the cap. It's very important, especially on the second bullet point here, about nonprofits affiliated with or related to an institution of higher education, to understand that there's a lot of misconceptions about that. Some doctors believe that you only have to be working for a nonprofit to be exempt from the cap, and others think that you only have to be working for an academic institution to be exempt from the cap. Well, of course, if you're working for an institution of higher education or at an institution of higher education, yes, you would be exempt from the cap. But in order to qualify based on affiliation, there needs to be a nonprofit entity that is affiliated with or related to an institution of higher education. We need both, the nonprofit status and that academic component, to qualify for cap exemption. And the documentation that's required to show that is pretty robust. It's evolved with USCIS over the course of the last few years, what they want to see to really prove these requirements. It's really important that your employer and your immigration lawyer work very closely together to make sure that the proper documentation is developed. And even then, even if they believe that all the proper documentation is developed, it's possible that USCIS is going to come back and issue a request for evidence and ask for more evidence regarding the affiliation. It's a really, really touchy subject sometimes with USCIS. We file a lot of these kinds of petitions, and the vast majority of them are approved. Every now and again, USCIS pushes back on something, and we have to address that and figure out if this is if it's a new trend or if it's just something that an examiner picked up on in one case. So, but cap exemption is definitely alive and well. And if you're on an H-1B for your training, I suspect a lot of folks are going to be looking for cap exempt positions, but they don't quite understand what that means. And so this is really what it means. When we talk about at the bottom of the slide where the employee will work a majority of the time at a qualifying cap-exempt institution, we're talking about a situation where you might be working for a for-profit company like a staffing company, but you're working at a hospital or other facility that might qualify under one of the reasons for cap exemption. We do a lot of those in my office. They can work out really, really well, but it's very important to look at the details and make sure that you can adequately prove that you're going to be working at least a majority of the time at that qualifying institution. A lot of the doctors I work with in that situation are working as hospitalists or emergency medicine physicians, so they're working 100% of the time at the qualifying institution. But we've done it for folks working less than that, but it's important to show that more than 50% of your time is going to be at that qualifying institution in order to be able to show that that petition is CAP exempt. Okay, so we've determined that you're qualified for the H-1B. We've determined that we've dealt with the CAP issues. We've dealt with all these other critical issues in determining eligibility. How do we actually file an H-1B petition? These last couple of slides in the presentation are going to talk about exactly that, so that you can have an understanding of the nuts and bolts of what's going on at your lawyer's office when they're preparing your H-1B petition. In my office, the first thing we do is, after we have a consultation with the physician and with the recruiter and kind of figure out all these nuts and bolts issues, is we send intake to the employer and the employee, and so we can get all the necessary information that we need to file the application. Once we have that intake in, especially the intake from the employer, we complete the first step of the process, which is filing the labor condition application with the U.S. Department of Labor. The labor condition application is different from the labor certification that you might hear about in the green card context. There's no advertising of the position required here. This is a completely different application, but it's a common mistake to make between the LCA and a labor certification, so I like to point that out. All employers who intend to employ an H-1B worker have to complete an LCA, and it includes certain attestations from the employer. When we file the LCA, it does not have your name on it. And it's important to understand because your employer is going to have to post it in 2 conspicuous locations at every single one of your work sites, including the sites that they might not own or control. Sometimes that becomes an issue where a hospital doesn't want to let a staffing company come in and post an LCA. And we have to kind of finesse that and explain to the work site, no, this is legally required if you want them to be able to recruit this physician. And they usually relent once they understand what's going on. But again, it's not going to have your name on it. It's going to list the employer's name. It's going to list the position, all the work site locations, the salary, and the prevailing wage. Sometimes we can use the salary range on the LCA, so we don't actually have to telegraph what the specific salary for the position is. Once it's posted, we can go ahead and file the LCA with the Department of Labor. It's filed electronically, and then the Department of Labor takes 7 days to come back and certify the LCA. I get those emails every night at 9 p.m. Central Time. For some reason, that is the magic hour for certifying LCAs at the Department of Labor. Once it comes in, we notify the employer. They sign it and email it back to us. Every H-1B must have a signed certified LCA in it. And then there are some other documents as well. So while we're waiting for the LCA to come back certified in those 7 days in our office, we prepare all the other forms, and we try to get all the other intake documents, all of your medical credentials and educational credentials and everything together, so that hopefully by the end of the LCA 7-day period or within a couple of days thereafter, we can go ahead and file the H-1B petition. Usually tell folks, allow about 2 to 3 weeks for the process to go through all of the intake process, the filing the LCA, getting everything else signed, and then the assembly of the petition together and all the other prep work that goes into it. So after the LCA is certified, when is the H-1B petition ready to be filed? Well, here's your shorthand list of your Cliff Notes list of what goes into an H-1B petition. You have to have the certified LCA. You have to have all the other H-1B forms, the I-129 and its relevant supplements that are all signed by the employer. You as the employee do not have to sign any of the H-1B petition documents. As we talked about earlier when we talked about payment of fees, the H-1B petition is one that legally belongs to your employer, not to you. So they sign the forms associated with the petition. If you're filing applications for dependents on an H-4, the dependents, your spouse or your children, they will sign the H-4. And actually, one thing I should mention in that regard is that USCIS is in the process of updating the I-539 application on which we file H-4 applications. And as of March 21st, the new form will be mandatory, and we will need a separate supplement for each family member who's going to be filing, which means that each family member is now going to have to sign those, and the fee has gone up. So now every person who files an H-4 is going to have to go for a biometrics appointment. And so instead of just a plain old $370 application fee for an H-4, it's going to be $455, and the fees are going to go up substantially as USCIS fleshes out this new form. So as I mentioned, that new form will be required as of March 21st. USCIS is going to start adjudicating those new petitions or working on those new application forms on March 25th. And everybody who files an H-4 on or after March 21st, or any application on an I-539 form, is going to have to go for biometrics. And what this means is that H-4s are going to take a lot longer to be adjudicated than they used to. And when we premium process H-1Bs and we file the H-4 along with it, USCIS is no longer going to be able to expedite that H-4 to be adjudicated with the H-1B. Because of that biometrics requirement, the person's going to have to go for fingerprinting and everything at a USCIS application support office. Because of that, they're no longer going to be able to expedite those H-4s and approve them with the H-1B. So there's going to be a big difference in adjudication time between the two types of applications. It's important to understand how that's going to work. And it's a brand new process that hasn't even gone into effect yet. And we in our office are already preparing to kind of deal with these issues. So that's a little segue about the H-4 and the new form. All supporting documents also has to be provided to the attorney or whoever's filing the H-1B petition before it's filed. It's very important that we be very meticulous and detailed in getting those documents from you. Back in September of 2018, USCIS implemented a memo that says, if you don't provide all of the required initial evidence with your petition, they can just go ahead and deny it. They no longer have to issue a request for evidence asking for that documentation. Now, in most cases, they still are, because sometimes there's a question or a gray area about what's actually required. But in other cases, if you provide, if your application is missing a lot of documents, USCIS might look at that and say, you know what, we're not going to waste our time with an RFE. This application is unsupported, we're going to deny it. So it's important to have all of these documents in place. The employment agreement, the employer financials, all of the employee's credentials, proof of current immigration status, medical license in the state where you're going to be working is crucial. If you're working for a staffing company or in that type of situation, an itinerary showing all your multiple work sites and the division of time that you're going to be working there. Proof of H-1B cap exemption if that's applicable, the filing fees, and any of the other relevant materials that might go into your H-1B petition. So it's really important for us to well document these petitions. They're not gigantic filings, but it's the specificity, the documents that actually go into it are very important, and we review those all very closely. Once the application is filed with USCIS at the appropriate service center, government processing times are going to vary. If you use the government's premium processing service, as I mentioned, they will turn the case around within 15 days, and that includes weekends and holidays. And what that means is in those 15 days, they're either going to approve your case or they're going to issue a request for evidence. They theoretically could also deny the case under this new policy. Thankfully, I have not seen that happen yet, and I hope that that continues. If you don't use premium processing, then your government processing times are going to vary a lot. We've seen cases recently that have gotten approved within a month, and then we've seen other ones take a good 8, 9, 10 months. So it's really hard to know exactly what the government processing times are. If you look on the USCIS website, you're probably going to see some ridiculous number. But we can file 2 identical petitions in our office and get 2 completely different results in terms of processing time. So it's just important to know that one person's experience, and this is really true of all immigration matters, right? One person's experience doesn't dictate what all people's experience is going to be. If timing of the petition is really important to you, if you just can't deal with the stress of having the petition pending for a long time because you need to know or you've travel coming up, then consider premium processing the petition. It can really be money worth spent to give you peace of mind and to get a decision on that application a lot faster than it might otherwise come. And with that, that is the last slide of the presentation. I don't know if there are any questions, but if you are watching this or listening to this on a recording or anything, you are more than welcome to reach out to me with questions. My contact information is on the screen, and I'm happy to answer questions.